It is kind of amazing to watch these numbers just tick up and up and up as we get closer and closer. We had more than 300
shows
people.
The need.
Yes, exactly. It does show the need for this kind of information. It looks like we've leveled off. So thank you guys and welcome to another live chat, what we're referring to as the night talks, because it is mainly Emily talking for a very long time to give a lot of information to our restaurants out there in Texas. Tonight, we're going to be going over, once again, the CARES Act. Now that CARES Act has actually officially passed and been signed by the president, we want to kind of dive into it and understand some of the pieces of it. There's a lot of confusion and nuance to it, understandably. Emily and I have been gathering your questions, and so she has a long list of questions to tackle at the front. And then as you have questions as well, go ahead and put those in the Q&A window, and we'll address them whenever we can. We also have a couple of guests with us tonight. Ethan Davis and Talley Parker are with JacksonLewis. They are part of the TRA Law Center. They're wonderful people and have been very, very helpful for a lot of our restaurant members. If you are a TRA member, you do have access to a legal conversation with these two and another one of our legal partners as well. So they'll be here specifically to answer questions related to paid sick leave, FMLA, and any other questions regarding the Families First Coronavirus Relief Act, which was really part 2 of the coronavirus acts that we've seen passed by Congress. So I know we have a lot of questions to get to. Emily, you want to just start us off?
Sure. Hi, everyone. Happy Monday, rainy Monday if you're in Dallas. First, I definitely want to thank Talley and Ethan. I think this is great. And I think having the 3 of us on will probably show a couple things. One, I really want to caution everyone that from the association's regard, and if you looked at my desk right now, I've got a tremendous amount of paper. And we are having dialogue every day with our federal team trying to sort through what all this means. But I think what's really important are 2 things. One, we actually don't have all the answers, nor do the folks that have to implement this, like the SBA. So as we go back to them, and one evidence of that is on Friday, there was a webinar, and it frankly did not go that well with SBA because so many of the questions that they were being asked, they just didn't have the answer to. So they sort of canceled these webinars for the next week. They're locked down, just like Department of Labor did on the Families First Act, and now have come back with 59 different responses to questions that have been posed to them for clarity. So I want everyone to sort of take a deep breath before we start and realize that if we don't know the answer, we're definitely going to get it because we're in rulemaking right now and kind of the regulatory side. So that's going to come out. And then 2, what I have found, each of your businesses, and you know this, are unique. And not all of you are sitting with the exact same number of employees, how long you've operated, how much money you need from a liquidity standpoint, how much you can borrow, how many loans you have. All of that to say that in my note last night to so many of you was go see your lender now. You do not have to wait for the SBA paperwork to come up or to be sent down to the lender or even the lender to actually be identified. In some cases, you can sit down with your bank right now to say, or your, what do you call it? Not the credit union, who you've lent or borrowed money through or who you do your business financing with, and sit down right now and say, this is my situation. They will talk to you about your goals, and then they'll be able to at least guide you on a path, but do not expect them to be the experts either. This is all going to become very fluid very quickly. By law, since the president signed this last Friday, SBA has 15 days to get this up and live. We were told this morning they think they could accelerate that for us. Respectfully, it's a government agency in the middle of a crisis, so I'm probably not as hopeful, but if that were to happen, great. If not, we will track along, and as a lot of the questions you ask, if we don't have the answer, know that they're going right up to DC, and we have a giant and super talented federal team that is helping to also sort through these, and then we'll just keep coming back with information. So before we dig in, I'm going to start, if it's okay, with the questions, because we have probably, I don't know, 30 questions that have already come in that we will answer for you the best of our ability. And then as you pose additional ones or other things we think you need to know tonight may just be the best way for us to handle that. So Talley and Ethan, any comments from you before we start?
No, let's get to the questions.
Okay, so first, for loan forgiveness, what about tips? And so when you're looking to see first 2 things, how much can you qualify for? When you're looking at your payroll amounts, should you be including tips that have been reported? The indication is that eligible recipients with tipped employees may receive loan forgiveness for additional wages paid to those employees. So if you are looking at that payroll over that covered period and you have tipped employees that you're reporting, that would be a part of what was considered to be forgivable, which leads us, again, from a guidance standpoint, to believe as they calculate and look at last year's same period, that they would include the tipped wages as well. Can I apply for a loan under PPP and also take the employee retention credit? Our understanding is no. The retention credit is available for eligible employers who closed due to the coronavirus, who pay wages to employees who are not working, and that eligibility is currently defined and will be limited to businesses that are either partially suspended or their payroll is 50% less than the prior year. And so we had some folks calling and saying, I'm going to take out a loan for PPP, and then I'm going to ask the government for a tax credit of half of the value of some of the salaries of people who aren't working. We have yet to hear that you can mix both. Right now, we're hearing that they are two separate. So if you've already laid everybody off or you have everyone at home and you want to kind of retain them, you can look at this tax credit as one option, because let's say your dining room closed and you're a high-end restaurant and there's no way for you to operate, you would actually benefit from this. But right now, mixing them is not the guidance we're receiving from SBA. What happens if I have an existing SBA loan and can't make the payment? The SBA actually has written in the CARES Act that the SBA will pay all principal, interest, fees on existing SBA loan products for up to 6 months. And that was my early comment, that if you currently are sitting on a loan, and this has come up quite a bit, and you're thinking about, well, that's not going to suffice because now my operations are all but ceased and I'm trying to survive. I need a loan to cover the forgivable expenses of rent, mortgage and interest, utilities. What do I do? Well, that's really good news, because if you are in a situation with SBA of already having an outstanding loan, it looks like, and I'll say in some cases, I'm always going to say in some cases, because nothing is ever 100%, the SBA will pay all of that principal, interest, and fees for you for 6 months to try to get you, the whole point, guys, with this whole piece of legislation was to keep people working and keep restaurants open as we speak about the world we live in. Will the SBA still require you to sign a personal guarantee? This is really important. We covered this, I don't remember the last time we all spoke was, but for the SBA business interruption loans, and think about those falling under that PPP program that you're hearing a lot about, it's section 1102, if you care, and it will provide small business interruption loans and loan guarantees directly through community banks and credit unions. And this is important, a max of 250% of payroll or up to $10 million. Borrowers do not have to pay any loan fees, prove they can't find credit elsewhere, that's that credit elsewhere test we talked about, provide collateral or a personal guarantee, or pay a penalty for prepayment. Now, why is this important? This was really done to speed things up. So just the credit elsewhere test alone can take quite a bit of time to process and go through all the paperwork. So many of these things were very big wins in the restaurant section of this, because it's going to allow the processing time to be much faster. And frankly, if some of you apply for that economic injury or were thinking about economic injury, if you're able or have that line of credit, you were coming back and saying, they're saying I'm not going to be eligible. This has all been removed from the loan portion of the PPP. Talley, Ethan, anything you want to jump in on? I know we're not to kind of unemployment stuff yet. Okay, good. Do restaurants, the forgiven part of the loan is reduced based on how many employees have already been laid off or furloughed. So if we have to reduce staff by 60 or 70% or more, will we get none of the loan forgiven? Now, I'm going to show you this because I'm going to post this as soon as we're done, because it's going to take me 6 hours. I actually just got the language. And I will post this after, which is the calculation that you will do that shows the employees from last year, the employees now in that covered period. It actually does the math for you, and it will tell you exactly how much of that loan will be forgiven. So just in the name of time and so many questions and so many people, I will post this section 1106 when we're done, Anna. We can post it on our site. And then all of you that are looking, you can just look at this and do the math, and then again, have a conversation with your accountant. Yeah, go ahead.
I do want to chime in there. I was having a conversation with one of your members earlier regarding the loan payback issue. Okay, and this member had said, "All right, here's the situation I'm in. I might be able to be exempt from the Families First Coronavirus Response Act, the FFCRA, because right now I have less than 50 employees. Okay, but this owner operator was concerned, or maybe he was a little above 50, I think, and he was thinking that maybe if I get rid of some people, then I might qualify for the exemption. But if I do have to lay off some individuals, is that going to impact the amount of the loan if I take one from PPP that I'm going to have to repay, right? And I looked at the guidance after that call. Frankly, I was talking with him. I said, I don't know. I'm going to have to look at that. And he said he was going to participate tonight. So I hope he's out there, and I hope he's listening. But I'd be curious to see if what you have in front of you generally comports with this. My understanding is if someone takes a loan, let's say it's $1 million loan, just for the sake of argument.
Sure.
And if they use all of that loan to pay payroll or to pay mortgage interest or to pay rent or to pay utilities, then the $1 million is not going to have to be repaid. Then we have to go look at the employee situation, right? I think that's that complicated formula you said that's on the piece of paper that you're looking at. I think that they might still have to repay the loan if they have laid off, if their workforce looks materially different than it did a snapshot in time, and the law itself provides what that snapshot in time is. You got to go back, and the snapshot is 2 periods. One of them is January 1 of 2020 to February 29 of 2020. The other is February 15th of 2019 to June 30th of 2019. And it's my understanding that you got to look at this formula, and you have a numerator and you have a denominator, numerator being the top number, and that's going to be the number of covered employees number of employees that you have during what's called the covered period.
Correct.
And the covered period, 8 weeks. The covered period is going to be the 8-week period after you take on the loan. Okay.
Yep. Loan origination date. Yep.
On the origination date. That's going to be the numerator. The denominator is going to be what your employee roster looked like in one of those 2 snapshots of time that I talked about earlier. And so the example that I have is, to make this kind of simpler for everybody, is if your company employs 50 employees during this covered period, which is going to be kind of looking to the future here, right after you've gotten this loan, but you employed 100 employees in January and February of this year, then the forgivable amount of the loan, whatever the number is going to be multiplied by I guess it's the quote, the product there, which would be 50 divided by 100 would be 1/2. And so potentially 1/2 then of the $1 million would have to be repaid, $500,000. But it's my understanding then that you've got to go and look a little bit further, and that the employer has an opportunity by June 30th to restore their head count to the level that it was at in the snapshot window, again, looking in the past. And so long as the employer restores the overall headcount window to that number, then the entire amount would be forgivable, assuming it had been used all for proper purposes.
That is really spot on. And you know what's funny? I just show you, and I don't know if you can see it, but actually the math problem is right here. And then what you talked about was restoring, because we go back to the intent of this was to give everyone kind of a soft ramp up back into reality of running our businesses, and giving you up until the end of June to not be negatively impacted by having to eliminate staff earlier when the crisis began. So you are 100% correct.
Right. So if I could, and this kind of dovetails with what Ethan can talk about whenever we get questions about it, what we did our webinar on 2 weeks ago, the Families First Coronavirus Response Act, okay?
Yep.
Because I think this is a situation a lot of your members might be dealing with, who right now, as we sit here today on March 30th, have, let's say, 55 employees, okay? They have less than 500 employees, so they're going to be covered by that law unless they get below 50 and can qualify for an exemption.
By April 1st, related to COVID, Yep.
So basically tomorrow is the 31st. So some of your members might tomorrow be thinking, might it be best for me to lay off some employees so that I'm below 50 so that I can possibly qualify for an exclusion or an exception to FFCRA without undermining my ability to still get a loan under PPP? I think the answer to that is yes. I think you can. Now, laying off employees, again, that's going to factor into this math equation, this problem that I just talked through and that Emily can send you guys the details out about.
Yep.
But so long as you then restored your employee role
by June
30th
Yep.
To what it looked like during one of these snapshot periods, you might have an opportunity to, at least in the short term, not have to be subject to the FFCRA while still being able to get a loan under PPP.
And I think this is such, I'm going to pause here for a second, just because I think this is really important. And I want to make sure we've sent it out in a lot of emails, but may have gotten lost, that on the 1st, this paid sick leave, family and medical leave, kind of those two big tenants will go into effect for those that have 50 or more, 500 and less. And the 50 and under, and Talley, I think you probably saw the same thing. We just got guidance from DOL today, which is how do you prove a hardship, right? And so we can also post that guidance. So DOL finally came back, Department of Labor, and said, this is what would qualify you, right, to be under that 50 cap and be able to get exempt from this. The only thing I'm going to add to this conversation is that from a business discussion, this is really important for you to be thinking about in TikTok the next 24 hours, right? Because April 1st is literally one day away. At the same time, I encourage you to have this conversation with JacksonLewis or someone else, the Texas Workforce Commission. Like, what you don't want to do is make an abrupt situation in hope of something and then harm yourself in the next 2 weeks because now you've let go of your top talent and they've gone off somewhere else. And so there's that retaining element. So I think spot on that this is something that needs to be in the forefront. We'd keep reminding people April 1st. But if you're right in that threshold and you still want that loan, like you said, this may buffer you if you do exactly what Talley said. So this is super good dialogue.
One thing I just want to chime in with, because I'm seeing a lot of questions related to it, and I know all three of you have heard this before, is what happens if a restaurant hasn't been open that long, so they don't have that snapshot in time to look back on?
Well, I mean, I'll let Emily weigh in, I think, from a CARES perspective, but as I was looking at CARES earlier, because in order, at least from the perspective of, I think, determining the amount of the loan that you can get, it's 250%. As Emily said earlier, it's 250% of the average total monthly payment by the applicant for payroll costs incurred during the 1-year period before the date on which the loan is made. As I understand it right now, it doesn't provide for a scenario in which a business had not been open for that full period of time. So I don't know what the measurement period would be for such a business. I can't imagine that that's going to somehow disqualify from them being able to participate in PPP. But Emily, do you have any additional guidance on that, at least as it relates to CARES?
Yeah, I do. So I'll tell you, here's your first for the evening of the madness of where things aren't aligned, right? So under additional eligibility requirements for this interruption loan under PPP, it said borrowers must have been in operation on February 15th of 2020. Okay, so you had to be in business by February 20th. So if you opened a business in the last 3 days, you, according to this from SBA, right, you would not qualify because you had to be in business before the crisis started. So that's a really important. But then it says later on in here, essentially is that you can look back up to 6 months on your business from the date of February 15th, which would make you believe, or after February 15th, which makes you believe that you didn't actually have to be in business by then. Our federal team has come back and said they believe it's very clear that you had to be operationalized by February 15th and that there would be a mechanism. So let's say you opened in October, they would take that 3 months of payroll or 4 months of payroll and then average out the monthly, and that would sort of be their 12-month run. So that is in there. I was hoping before this call we would actually get the actual, this is exactly how it's calculated, but you should be okay as long as you were in by the 15th. And one of the later questions was, I bought my business and started it in December, but I bought it from another organization and another individual. Their tax, obviously, documents and everything they've reported were part of that sale. Can I submit those documents because they were part of the transaction that occurred, federally filed documents? Our response back was yes. So if you've just bought that business in December and now you're afraid you don't have enough payroll or you started slow to ramp up, we got back that you are able to, and our understanding is that you can take those documents because they were filed tax returns and everything was reported and use those in your evidence as you apply. Does that make sense? Yep.
Yeah,
okay.
And I would like to know just one distinction for the FFCRA. For the time period that you're going to be looking at there, It's not the April 1st date when it kicks into effect. The 500 employee threshold is implicated by the date that the employee's leave is to be taken. So say you have 500 employees on the dot on April 1st, but then 3 employees want to take leave, and those are your first 3 employees. You're at 500 employees, or say you're at 505, and 10 employees want to take leave starting at the end of April. That's the time you're going to look at. So if you're at less than 500 at the time the employees want to take leave, it doesn't matter if it's April 1st, April 30th, May 1st, May 30th. That's the time period you're going to be looking at to see whether you're a covered employer and whether you need to provide this extended FMLA.
That's a great point, right? So if you've got 502 and you go, great, I'm not part of this deal, and then on May 1st, 6 people go out, you're now having to actually execute on the families first, right?
Next, yeah.
Until the end of the year, right? It's till December 31st, 2020 is how this.
And then it's over at that point.
Exactly.
And then it's over. So I think that's important too. This is not a forever. That's a debate for another day right now in this whole category. But this would mean that you on the 1st of April, this covered and benefit you have to provide above 50, below 500 is until the end of December. So I think that's a really good point as people plan out. If you're on those brinks, right, either direction, that may be pretty important to consider. Thank you, actually. That's really good.
Yeah, it is. One thing I'd note, though, Ethan and I were talking about this right before we went live here, though. You know, the additional form of FMLA leave, though, that you can get under FFCRA, you can only get that FMLA leave if you know, a school or a child care provider is not available, right? And for that circumstance. And you've got to think that while that form of FMLA leave could be used through December 31st, we would certainly hope, right, that schools are reopened, you know, late May. If they're not for the school year, fine, maybe by August.
Let's hope so.
So you would think that FMLA provision, while it goes to the end of the year, that in reality, hopefully it won't, right? And then similarly, most of your employees are going to be taking paid sick leave under the FFCRA. Hopefully aren't taking it because they themselves got coronavirus or a loved one did. Hopefully they're only taking it, again, because the schools are closed. And so
that's right.
if you're an optimist and you think that we're going to be in good shape this summer and certainly by school starting in August, then you shouldn't really have to worry about that too, even though it could potentially be taken to the end of the year.
Mm-hmm.
Great point. Good. All right. Thank you both. Let's we're going to keep moving. So since we closed our restaurant and laid off all of our staff and we apply for an SBA loan, do we have to bring all employees back or can we do it gradually? And here's my understanding that if you bring them back before June 30th, right, you would look at the repayment of all your payroll costs up until that point would be able to be forgiven based on the number, that math that you do for the number of employees. You have essentially an 8-week covered period that you're able to go back and say, I'm going to have this be non-repayable. But by bringing them back much slower, you're going to have a much lower threshold of employees that you would be able to use for payroll for that forgiven loan. Does that make sense, Talley?
No, it does. It does.
Yep.
Yeah. So I guess if you're not bringing back as many of your employees, then you're going to have to be using that loan for another permissible purpose, or I guess an impermissible purpose. But there, you're not going to get the credit for when you know the extinguishment of the payback obligation if you're using it for an impermissible purpose.
Right. So either, and if you used it for rent, or it'd be for that period of time as well. But that's clearly, unless you have exorbitant rent, which some of you may, but
right.
The payroll is the big win on the non-repayable portion. Okay, so this one is interesting, and I'm going to say this, but I'm also, and I can't see, guys. Some of them I know who asked them because the name is in. This one I don't. But if this is your question, if you don't mind just sending us your email address, because this is a little bit complicated. I have several franchise brands and LLCs and would hit the 10 million maximum in more than one LLC. I also have other businesses in LLCs that are not restaurants. What are the rules associated with the PPP regarding receiving loans in more than one LLC? our understanding is you get a little bit into this affiliation rule around franchisees, and franchisee affiliation rules are also waived, allowing individual franchisee locations owned by a single business interest to each qualify for assistance. My understanding is that this would apply to you, but because this is a little bit more complex and more around how each of these LLCs is structured, if you don't mind now just posting your name that you had the franchisee question, we can just talk about this one separately, because it's just got more complexity to it with the size and how many make up and how those LLCs are actually, if they are all attached to each other in any kind of way. Because when we get into the franchising stuff, it gets, you know, all of you have different structures. So we'll just want to do that one separately.
Yeah, I found his information, Emily.
Perfect. Okay, good. In regards to being able to carry back the NOL, right, which is the write-offs, does this apply to businesses or personal? My business entity is a sub S corporation and the profit loss carries over to my personal return. My bottom line answer on this is you need to check with your accountant because it goes back a number of years. You can go all the way back to 18. And so this sort of it's currently subject to taxable limitations and cannot be carried back to reduce income in prior tax years. This provision has now provided that losses from 18, 19, 20 can go back 5 years. And so you would have to, I'm assuming, be structured the same way the last 5 years and not have anything new come in and out. But this would be one I would go to your accountant and say, there is a provision in here. This is what we can do. And then depending on how this is shown up on your personal taxes versus your business, they're going to have to determine if you're eligible now to go back and write off these losses. So that's one for your accountant. So what is the protocol for helping the franchisor? I thought that was just really interesting. Our franchisees are being helped, which is super, but their sales are off and we're struggling for revenue with much reduced royalty and marketing fees. It's something for us to think about. We have waived the fees for 2 weeks, trying to help, of course, but it's adversely impacted our revenues. What I could find for you was the Emergency Stabilization Fund, which is another category under this sort of large 2.2 trillion that is for medium-sized businesses. I don't know how big your business is, but looking at this and knowing that you probably have a number, I'm assuming that you don't qualify or you probably wouldn't have asked for the small business loan. The only other thing I could find, and there's a number of them, there are, try to find it for y'all. There is a number of loans under each of these categories, but really if I read this question, I think the only option for you would be the Emergency Stabilization Fund, which is geared towards medium-sized businesses. So I would go and look for that. And I think it was Dick who asked that question. If I'm a seasonal employer, this is a good one too. I'm a seasonal employer. I love details relating to seasonal employers and how we might calculate things for the PPP. The guidance that we have, which is, I believe, correct, the maximum loan amount for seasonal businesses under business interruption loans, so CARES, is calculated as the average total monthly cost can be based on the average payroll per month occurring between February 15th and May of 2019, or March 2019 to June 30th of 2019. So I believe they give you 2 windows to see which seasonality you fall in, and that's how they're going to calculate it. So there is language for seasonal employees and how you'd calculate that benefit specific to you. We talked about the fact that you can use your previous documents from what the business the year before produced. Let me just make sure, guys, and look at some of these we've sort of answered on the way. Yeah, okay, a couple of people have asked, Emily, there's all these loans out there. What is available? There's 2 loans, there's disaster, there's economic injury there, and I think we're getting a lot of these names interchangeable. But what we have here is if you're a small business that meets the SBA side standards, you have business interruption, which is CARES Act, economic injury disaster loans, SBA express loans, relief on existing SBA loans we talked about, and the Emergency Stabilization Fund. For most of you, it's going to be the business interruption, which is under the CARES Act, or the economic injury, which we talked about, gosh, now 2 weeks ago, which is the up to 2 million threshold. So that should answer that. If you apply for a disaster relief loan, can you also apply for the CARES Act funding? And if so, are both loans forgivable? One of the lines that came out today from SBA is for the business interruption under the CARES Act, the borrower did not get an SBA 7A loan or other interruption loan for the same purpose or has one pending. Talley and Ethan, I don't know if you want to weigh in. It's the idea that many people went out and pursued economic injury when it was the first, but there was a lot of hangups with it, frankly, that if you were able to get, they had a credit elsewhere test in that particular loan mechanism. So many people came back and said, this is not going to work for us. Or they already went through the paperwork with their bank and are thinking that's going to land, but are now wondering, is the PPP the better option? My understanding is that you can't do both.
I do not know the answer to that.
Okay. So I don't know if someone wants to weigh in the chat box, but who's had this conversation with their bank, but our understanding is it's one or the other on those specific loan types, because they're both for this one event, which is the COVID-19. So that you wouldn't be going after two of those loan mechanisms.
Someone in the chat box did respond and say you can do both.
You can.
But I don't know who this person is. So
okay, I'm sure Joy is awesome. So
are saying that you can do both, but
yeah. Let's find out just to be sure, guys, because you also, I mean, this is where it goes back to those conversations with your lender about where can you maximize, where's the write-off opportunity. Maybe you get 2 million from up to 2 million with the economic injury, but you can actually get a much more forgivable portion, like Talley suggested, if you go to the PPP. So yeah, and so Joy actually talked to the SBA, and then someone else said, of course, the lenders don't know. So, I mean, we had many banks today send us notes saying, why are you sending people to us? We don't know what PPP is. And that gives you any kind of comfort. Once I've been approved for one of the loans, does anyone know how quickly it will come? Our hope is that by removing all the requirements under the CARES, the PPP loans, that they will be processed faster. That was the intent of pushing for no collateral, no personal guarantee, no credit elsewhere test. The idea was that things would move along quicker. We do not have that answer for you tonight, nor does SBA. Where do we fill out the forms? I can't find the forms online. There are no forms online yet. If you go up to SBA now, you will find some disaster forms. Those are not what you're looking for. Go to your bank, go to your credit union, have the conversation. We, as a TRA, will post immediately when the documents are available, but your banks will also get those pushed down, or the lenders that are identified as SBA lenders will have those materials as well. I think that's it on this. So Anna, maybe we can get into some of the questions that may have come up tonight, but this is sort of the pre-ones I have. Oh, last one, and this is, I'm probably gonna let the Jackson-Lewis team, does the 600 apply only to those who apply for unemployment benefits? Is this Texas only? And my comment to you is, it's not Texas only. This is something that's national. The 600 would go on top of your eligibility for unemployment, and that is by state and by what your current income is. But I don't know if you two want to kind of jump in, because this is going to get into the question, and this person actually extended it, which is, Emily, if someone's making $50,000, they can actually make more sitting at home with an extra 600 a month and about 260 in their benefit, right? Just under 300, because I think 521 is the max. This is coming up a lot, guys, in that if you make 50 grand for the next 3 months, you can sit at home and make just as much being unemployed. Clearly no benefits. Clearly there's a lot that's not good about that. But I know our employers are going to be asking this, because they're going to want to start bringing back employees. And if they're incentivized to sit home with this $600, what do you guys think about that?
Yeah, that's a good point. So, I mean, in Texas, as you noted, the benefits ranges that folks can qualify for on a weekly amount is $69 to $521, right? So you take someone who maxes out, they can now get $1,121 a week. If you were to annualize that, and now keep in mind that the $600 supplement is only going to be in place until July 31st, right? So that's not going to just hang around until the end of the year. But for the next 4 months, someone maxing out could be making what would annualize out to $58,000 a year. So that's part of the reason why this bill got hung up in the Senate last week, is you had Senators Graham, Sass, and others who said, hold on here. We're going to be doing means testing with respect to the stimulus payments that we're going to be mailing out. Not everybody's going to get that. Not everybody needs that. We should be doing the same thing here with unemployment, because otherwise, as you said, this is going to incentivize folks not to go back to work, which is not the object of this legislation here. But it very well may have that effect, or it could also have the impact of employees going to their employers and saying, "Hey, look, I know you're struggling. I know you're having a tough time right now. Go ahead and lay me off. I'm fine with that. I'm going to end up probably making more money than I would if I stayed here and worked for you." So, you operators out there, you might have some employees who are coming to you wanting to be laid off. But I think what it does, though, is if you are in the unfortunate situation where it's not your employees coming to you, but rather you're having to make the decision, no one wants to have to lay someone off, but at least now you know that person is getting a little bit extra of a safety net, right? At a minimum here in Texas, they're going to be getting $669 a week.
And I think on this is when we had a webinar with the Workforce Commission, what's really important for our employers is that if it's a COVID-19 event, that it will not hit essentially the employer account in a direct way. And so do you want to talk about that at all? Because I think there's some fear that, yes, I probably would be better off letting some of my employees go, but is that unemployment of that individual, if there's 10 of them, going to come back and hit my employment account with the Texas Workforce Commission, right? Or be a negative impact. And our understanding is from the Texas Workforce Commission is that there is not going to be a direct, there will be a credit back for a COVID separation. However, long-term, there may be some tax implications coming down the pike just because we have to replenish the fund. And so I don't know if you want to get into that at all, but I think it gives some employers a little bit of comfort.
Yeah, that's consistent with my understanding. And the webinar we did 2 weeks ago, we noted there that the TWC had put out some frequently asked questions, and the frequently asked questions, I think, discussed that very scenario. If I'm recalling correctly, it's the last or the next to last question, and you all can go to the Texas Workforce Commission's page. At the top, it says COVID link for employers. Go there, scroll down, and there'll be FAQs for employers. If you click on that, it's a Word doc, and they've got some really helpful guidance out there as well on these issues.
Yep, that's right. And I think that's important because it seemed in the collective sigh of a relief when we had the webinar that, okay, this may be best for employees, and I can then hopefully tether them and have a relationship that when we are, in a good place, but I feel better about that termination decision because they will be okay, at least for the next several months, if this is the income window they're in. So I know one of the things we talk a lot about dollars and cents, but I can tell you from all these phone calls, and I'm sure you've had them, people are also desperately worried about their own employees. And I think a call I had earlier tonight was, I worry about all the investment in skilled labor and individuals who don't want unemployment, but go to the grocery industry, they go to Amazon. We got a letter today about all these companies hiring for quite a bit of money that have massive job openings. And when we start to reopen, we got to have that talent. And so that personal connection is going to really matter, I think.
Right.
So, okay, Anna, do you want to start surfacing the easiest questions first?
Sure, I will start with the easiest. I actually have been sorting that out for you guys. Here's one. Remind everyone what the measurement period is for the Paycheck Protection Program. From what month to what month?
Which measurement? Oh yeah, go ahead.
Are we talking about for the amount of the loan that you're eligible to qualify for, or looking at the snapshot that will determine how much of the loan you might have to pay back if you don't ramp back up?
Let's go with the amount of loan you're able to apply for.
It's my understanding that you can receive a loan in the amount of 250% of the average total monthly payments that you have for payroll costs incurred during the 1 year period before the date on which the loan is made, or $10 million, whichever is greater.
Okay. Correct. Mm-hmm.
And then I have a few questions from people that kind of go back to that whole what happens if they haven't been open that long. Unfortunately, we have someone here who says, what if you were set to open in April and have fixed costs associated with that, but have no payroll to look back on? Is there any option available for that person? Because we know a lot of people were planning to open, springtime in their restaurants.
Yeah, my understanding is if you are not open and planning to open, that you would not benefit from the PPP loan program, because those are this $349 and the loans that fall under it were really designed to help those that are currently impacted by COVID-19. You may be able to make the case that your business plan was operationalizing in April, but from everything I understand, I don't know, there would be potentially another loan option for you. But Talley and Ethan, I mean, again, this is probably a little bit out of our realm because we don't know what you've had invested in, how many employees you've had on the books, all of that, but you're not actually operating. And so my understanding would be that you wouldn't.
Yeah, and I wasn't aware of the date until you said it earlier, but I think earlier in this program you said that they were going to look back at establishments that were open as of February 15th, right?
Correct. That is exactly what it says. Yep.
Yeah, and so if you weren't open for business or operational on February 15th, perhaps there is some exception, but seems like that's going to be kind of the marker date.
Yep, that's what I mean, essentially, and it's really right from the SBA site of Section 1102 of the CARES Act. Borrowers must have been in operation on February 15th of 2020. And I think that's really about when the crisis hit a peak, right? Or we started to see, okay, we're going to have to start, especially in the restaurants, we can track back that far and look at the volume start to fall. And so that's sort of the period they're looking back at.
Got it. Okay. One person is asking, is the economic injury loan forgivable?
No, it is not. There's
Okay.
there is the economic injury. You may be able to work out something with SBA, but the economic injury is not, does not, in my understanding, have a component that has a measurement where you can look back and write off and not pay back. Essentially write off meaning not have to repay a portion of the loan. That was specifically put into the PPP. Ethan, and I know this is a little bit out of your window, so feel free to say, hey, not our lane. But the economic injury, which is up to 2 million, that came out first, I do not believe there's a portion that you will not have to repay back. But again, this is something we can take, we're taking all these questions and we can repost, but that is my understanding.
Okay. Switching up back to PPP. For PPP, is the 500 employee test or threshold based on each EIN, or is it based on a combined control group status under FLSA? For example, a consolidated company that has several subsidiaries with different EINs, each of which have less than 500 employees, but in total have more than 500 if viewed as a consolidated company.
They have to go to their accountant. Yeah. It's too complicated. I don't know how they're structured. It seems like it'd be easy, but I can tell you this, that if you're operating under that classified system code of 72, which is accommodations and food services, there's a separate carve out for restaurants, hotels, caterers, and food service. Those are the only categories. And it was done because once you add up a number of outlets, for most of our, even if you have 5 or 6 units, you're going to already hit your max, right? But yet none of your units are above 500. So this carve out would lead me to believe there's opportunity for you, but I think you have to check. And I know someone just posted that it's up to the 10 million, but I would ask, just because of the way this is structured, but I would tell you that I've had a number of dialogues, some of our very big restaurant groups, and one of them said he believes this alone will save him up to $25 million. As he looks across what he's able to do. So I would assume that you actually probably have an opportunity here because of the carve out we were able to secure with the hotel association. But I would just go to your accountant and say, and actually, you know, we can post this one document I've been working off of tonight. And that's, you know, I think you'd probably qualify because it specifically says only small businesses that employ less than 500 employees are eligible. However, restaurant, food service, caterers, and hotels that employ not more than 500 per physical location of any business are also eligible to receive a single loan, and that loan would be up to 10 million or 2.5 times your payroll, monthly payroll. So I think you're okay. That's my assessment. But again, don't work for SBA, just interpret all the stuff we get. So I'd certainly ask your accountant or ask SBA directly.
Yeah, I'm trying to read through all here. There's a lot of very, very complicated, very specifically nuanced questions within the Q&A window, guys. And like Emily said, if you have an accountant or a lawyer you can talk to, that's probably the best thing to do. We'll try to address as much as we can here. This is an interesting question. They've been in business for 12 years, but changed from an LLC to an S Corp in July of last year. Would that affect their loan application calculation or chances?
Do we know what their size is? Do their size put them in the SBA category?
I got nothing.
Okay. I don't think it should, actually. Yeah, I don't think it should. I actually don't think it'll matter.
I do have one bit of clarification to share. Kyle Citrano chimed in and shared a document with me just a moment ago that came from the Waco Chamber of Commerce. And says your business may receive an EIDL, the Economic Injury Disaster Loan, SBA loan, and Paycheck Protection Loan as long as they serve different purposes. For example, you may receive an EIDL for working capital and a Paycheck Protection Loan for payroll assistance. And that's what Kyle just shared with us. So that's just some
And
clarification.
Kyle's super smart, so we trust Kyle. So it sounds like you can, you can use both, but that actually would make sense because the language I read is the borrower did not get an SBA 7A loan or another interruption loan for the same purpose or has one pending. So Kyle's guidance from that chamber would mean you could take out an economic injury for, as you said, working capital, and then take out a PPP loan to pay for payroll. Maybe it's utilities or rent. And so it sounds like you can, and that as long as you go into this, which is why it's so important not to rush and just fill out the first available item last week, is to put these both, go in and say, I want both of these. If you need to do both, remember, you may not need to. You may be able to borrow enough through the PPP that you don't want to manage 7 different loans. And so I'd also still encourage you, the PPP is so comprehensive that if you haven't gone down the economic injury yet, I would have the conversation about the PPP, see what the max amount is you can get. If you need more, then you have the economic injury in your back pocket. But know that you do not want to apply for the same use of funds, which is exactly what this says here. So Kyle, thank you. Huge help. Way to go, Waco.
If he's wrong, I'll give you his email address and you can address it. Okay, so Jeffrey asked a question earlier, and he says, must I restore 100% of my staff by June 30th in order to get a forgivable loan under PPP? What is the 75% rule?
All right, I'm going to look for that. Hang on, because he's correct. You have, there is a credit. Let me just find it, guys. Here it is. This is back to our very fancy calculation here. Let me find the 75%. Hold on. Everyone's waiting for Emily.
It happens. Yeah, I thought it was.
Hang on, guys. I have like 7 different documents here. I do know exactly what Jeffrey's asking, and there is an amount you have to, in that calculation that Talley and I spoke about, there is a percentage that they would like to have back employed, right? Which is the whole point of this program, really, is keep
Emily,
and then
I have
rehire.
a question that maybe Ethan and Talley can tackle while you're looking that up.
Perfect, because I'm going to find this because it's important.
Sure. So Talley, this one, this came up whenever we did the webinar with you a little while ago too. Can you walk us through sort of the decision process for employers to choose between laying off employees and letting them collect unemployment and the other option of taking out loans to pay for them?
Well, I mean, I guess you could look at it 2 ways. I mean, if you did lay them off, as I said earlier, depending upon what they earn with you, they could end up making more perhaps from unemployment than they would with you. But if you did lay them off, even though they might make more, you might run into that talent issue that we talked about earlier of now you've lost them, you've let them go. Are they going to be there when it's time for you to reopen, right?
Right.
That's kind of the issue that I see there.
This has come up in the Q&A window too. Some people have asked, what happens if I am able to reopen and I want to staff up and my employees won't come back? I don't really
I got it.
That case.
I found it, guys.
Yeah, but I don't.
Go ahead, I'll finish that.
I think we got a question about that earlier, though, right? I mean, if you want to ramp back up, you want to have that loan reduced, you've got to restore the head count. But it's not, hey, I had Ethan as my employee, I laid him off. I gotta get Ethan back, right? I mean, Ethan could go down the street and go somewhere else. I just got to get a body in there to be Ethan.
Exactly.
So
you can get him married.
The number of games.
Which ultimately that's the goal. They want higher employment, so they're just looking for someone to be back in that position. And it's a good thing if someone has left. Assuming the talents are equal, someone's left your place of business, gone somewhere else. They're working, and you can bring someone else in. More people are being employed, so they're not going to penalize employers for not bringing back the same exact person to fill that head count.
Right.
Exactly.
That's a really good nuance. So let me read this on the 25%, 75. So the amount forgiven will be reduced proportionately by any reduction in employees retained compared to the prior year, and then reduced by the reduction in pay of any employee beyond 25% of their prior year compensation. So essentially, it looks like you have to restore to 75%. Is what I'm reading of that number that you had is I don't know, well, maybe just stop for a second. That would mean that you have to restore by June 30th 75% of what you had the year before at the same period, correct? I'm looking at Talley, Ethan.
Yeah,
They're like,
yeah, I'm not familiar with the 75% requirement that the question is referencing and that you're talking about exactly.
yeah, it's under loan forgiveness, and it says right under it, to encourage employers to rehire any employees have already been laid off. And again, we'll go back, doesn't matter if it's Tom who got laid off, you can hire back a Mary. Due to COVID-19 crisis, borrowers that rehire workers previously laid off will not be penalized for having a reduced payroll at the beginning of the period. So this whole math of how much at the beginning of the period that you're able to then be forgiven, if you hire people back, it will not count against you for having a lower number at the start. So I think we're back to this math equation that I have to post for everybody, which is essentially numerator, denominator, and then this comes out to what you owe. So I think the 75 is the intent is to get you to bring back your workforce, not being the same exact people, but people who've been let go, bringing them back. I think that's what this is here, but let me just go back because it's on two different documents, but that's my understanding.
This is a question, really it needs to be put towards Texas Workforce Commission, but Emily, maybe you remember it. Employees collecting partial unemployment insurance, where'd it go? Employees collecting partial unemployment insurance for reduced hours. So they're still working at the restaurant, they just have reduced hours. So they're using unemployment to make up that gap. Will they also be able to collect the extra $600 that's been promised in CARES?
Yes, they will be.
Yeah.
They will be, yeah. I'm looking at some guidance and FAQs that we have on that. And it says that the expanded assistance, which is the extra $600 supplement, does cover employees during weeks of unemployment, partial unemployment, or inability to work caused by COVID-19. So yeah, those individuals, you know, their weekly benefit, because they're partially employed, is going to be less than someone who is totally employed. But no matter what that number is, they're still going to get the full $600 because that's a flat fee coming from the federal government.
Right. And I think that's important because we do have that shared work plan, or when you can actually be 20 hours at the restaurant and then collecting unemployment for the remainder that you were working before. Plus the 600 may be able to have some of our restaurant owners keep some of their best talent, put them on a much further reduced plan so they don't lose their very best manager, because they also now have the 600 buffer that they wouldn't have had before, at least for a number of months until they get back on their feet. And so I think that's something that we've talked a lot about, is that you can have unemployment and still be working in this case, plus your 600. That may not be a bad scenario for some of our smaller businesses that really, and I do think of a Kyle Sertrano and George's that has employees, or many of our restaurants, for 20, 30 years. You don't want to lose them in this. That is your top talent. So can you get something where if you're only doing takeout, delivery, curbside, keep those people and then let them use the alternative hours for unemployment? That could be a real win for the short term. Oh, good. See, he's already done it. Oh yeah, let's let's make this one, because I think this is important. Lisa just jumped in and said what has to happen by the 1st. And so Talley or Ethan, do you want to just say one more time kind of what this next 24-hour window is and what the requirement is on the 1st, which is coming right down the pike? Just one more time for people who jumped in late.
Yeah, so on the 1st, with regards to the FFCRA, you're going to have both the paid sick leave and the amended FMLA. Those will go into effect. And the way the paid sick leave works, because you know it's not the way some people's PTO works, where you accrue it. You know, for every 40 hours worked, you gain an hour of PTO. This will be all full-time employees. All employees who work 40 hours a week will have 80 hours of paid sick leave in their bank come April 1st. And that's something that they have. They don't accrue it, they'll have that. For the DOL's just issued guidance for your non-full-time employees, those who work less than 40 hours a week. And they'll have, generally, assuming, you know, they have a consistent part-time schedule, they'll have, you know, if they work 20 hours a week, they'll get 20 for each week, so they'll have 40 total hours. And then it's a little more complicated if it's someone who has inconsistent schedules. They have a 6-month look-back window where you can kind of take the average. But generally, you're looking full-time employees, they're going to have 80 hours of paid sick leave as of the 1st. Your part-time employees, they're going to, typically, assuming it's kind of a consistent schedule, you'll take, what they had for the previous 2 weeks, and that's how much PTO that's how much paid sick leave, they'll have in the bank as of April 1st.
And then the other component of that is the FMLA piece, right? So if someone has been working for you for 30 days, there's going to be this additional circumstance where they can get FMLA leave if their kid is out of school, if they don't have a caretaker, someone around to take care of a child. That's going to be another qualifying reason that they can get FMLA leave as well.
Yeah. And again, just remember, I think we kind of touched upon this earlier, but this is an amended FMLA. So the regular FMLA that you all know is still in effect. So if someone, one of your employees has, had a surgery earlier this year, they were out in February and they missed 3 weeks. They took 3 weeks of FMLA leave for a surgery. This amended FMLA leave, assuming that you're a qualifying employer, and they're a qualifying employee, they will get only 9 weeks of this amended paid FMLA leave. They don't get 12 weeks on top of the 3 they've taken for 15 total FMLA weeks this year. It's 12 maximum up to, and so if you've taken 3 weeks already, you can get 9 of the amended. If you've taken 10 weeks of FMLA already this year, you can only get 2 of the amended FMLA. And so just keep that in mind. This isn't something where if someone's already taken 11 weeks, they're now going to get another 12 and suddenly they're out in FMLA for 23 weeks in a year. That's not what this entails.
So that all takes effect on April 1. But I think the important thing to note here is for the FMLA leave, the new FMLA leave, someone can only use that for the purpose of the school is closed, there's not a caretaker. And then for the paid sick leave benefits, again, the vast majority of your employees are going to be using that paid sick leave, those 80 hours if they're full time. It's going to be for the exact same purpose. The school is closed, they don't have a caretaker. Really, the only other permissible purposes are going to be, if they've tested positive for COVID-19, if one of their relatives have tested positive for COVID-19, if they have symptoms, related to COVID-19. Otherwise, it's not just additional paid leave that they're going to use for any purpose. It's really going to have to be tied to COVID-19. That's the reason it was passed.
And I think one of the keys is we have a lot of people asking about the less than 50, and the DOL's questions that we sent in, meaning collectively universe 58 and 59, talk about the tests that they will do for small businesses under 50. And there's sort of three elements. The provision of paid sick leave or expanded family leave and medical leave would result in the small business expenses and financial obligations exceeding available business revenues and cause the small business to cease operating at a minimal capacity. 2 is the absence of the employee or employees requesting paid sick leave or expanded family or medical leave would entail a substantial risk to the financial health or operational capabilities of the small business because of their specialized skill or responsibility. And 3 is there not a sufficient number of workers who are able, willing, or qualified essentially at the time to perform this duty. And if that is the case, the employer has employs fewer than 50 people, leave is requested because of the child's school or place of care is closed or child care provider is unavailable due to COVID-19, or an authorized officer of the business has determined that at least one of the 3 conditions described above, those 3 things I read to you, is satisfied, then as a small business, you would make the case to be exempt from this particular 50 or under. Ethan, this is what we just got back from DOL tonight, so.
Yeah, that's a brand new regulation. Those were just added. And again, kind of going back to the beginning, tying a nice bow on this. This is such a fluid situation where they're coming out with these regulations. What was there 2 days ago is different than what's on there today.
Yeah, that was in there this morning.
And even say, they've updated it today, and they've still said they still have come out and said more are to come. They have, they've told you how you may be able to meet the small business exemption, but they haven't told you how to apply for it.
Correct.
So
and it says don't send us a letter, and I'm like, but you're the department who's enforcing it. So hopefully we'll hear that tomorrow. But I think for all the folks, and I can see a lot of the members that are asking, I know your business sizes, we can send this out as I think Ethan just said. It just came in because there was no guidance of how you become exempt, and now they've set the parameters. But we still, in here it says, if you believe you qualify for the small business exemption, don't send us a communication. It's honest to God what it says. So it's like, who are you supposed to send it to?
But I think that the issue there is going to be, you better be pretty darn sure that you got a good case for this exemption, because the problem is, as we've noted, the law takes effect on April 1, right? And so it says, go ahead and document your reason, be prepared to show why you don't meet the exemption, right? Well, like, when is that going to be decided? It's obviously not going to be decided for weeks or months down the road. And if you have not granted the paid sick leave, if you have not granted the FMLA leave to your employee base, and you've got employees who are saying, I would have used it, I needed to use that. If you're not able to satisfy the exemption, I don't know what the remedy is going to be, but I could foresee those employees or the government DOL, someone seeking some recourse against you because you haven't provided these obligations that the government would have then, by saying you don't meet the exemption, said you should have been providing.
Yeah, I think, guys, this is where it comes in. If we can help you at a high level or point you in the right direction, obviously we have incredible partners here with JacksonLewis that I know if many of our members are taking advantage of our law center, but also looking at deeper conversations. I would certainly encourage that. As we're kind of crossing the 9 o'clock threshold, I'll also tell you that today we began the dialogue on 2 things. Our national association is sending a formal letter on rent forbearance and to all governors. We will now begin dialogue in the state of Texas for around our businesses related to rent. We know we've seen lots of national dialogue about businesses being unable to pay. We've seen forgiveness for our individuals in many cases, but not for business yet. So one thing that will begin is conversations from our association and a kind of a group of associations now around what can we do for small business. Yes, it's great if you get the PPP loan and you don't have to pay that back, but it's only for a certain period of time. We have many businesses right now that they just can't pay today's rent, let alone waiting for this to come in. So we believe there's a really strong case, because I'm going to say it again, we didn't harm our business. We are part of a pandemic, but we were essentially closed by a government order, right? By our government saying you can no longer operate the biggest revenue producing part of your business. So that's one. Second, this is called business interruption loan or business, but we have still not addressed the fact that 99% of insurance companies are telling their members that COVID-19 does not count as a qualifying event for your business interruption insurance. We have begun and believe that phase 4, which will be probably the middle to the end of April, and remember it's almost April now, we will start the dialogue about what we want in the phase 4 package federally. So we got 2.2 trillion. We believe there could be another 2 trillion after this. And I know that's hard for anybody to get their head around, but what we had is going to help, but it's not enough, in particular for our industry, or frankly across the nation, especially as if this shelter in place continues for months. We feel really strongly that the insurance companies need to be backstopped by the federal government and essentially pay out those loans, right? So, or pay out those policies, because in some cases we have people paying $500,000 a year for business interruption insurance who were told, sorry, COVID-19 doesn't qualify. It's not a qualifying event. So that is another piece that's going to be very important in that conversation. And of course, the meals tax credit that you heard the president talk about preemptively, I think, that is another piece that will be probably less important. For me, I think the business interruption is a huge priority for us, because we have so many businesses that are looking at that and getting notes back saying, I'm sorry, you don't qualify. That's when we're going to hammer home, and we're focused on rent. And I always talk about, before I leave these calls, around mixed beverage and alcohol. We had a very big conversation today with, I think, 5 different associations, 6 associations. The bottom line is the governor and his team are probably, very rightfully to say, we're trying to save lives. We're turning convention centers into makeshift hospitals. Are we really going to talk about alcohol in a cup again, right? So we are taking a giant step back, and we've kind of put a bunch of groups together to say, let's demonstrate the supply chain impact of beer, essentially sitting, going stale in these businesses, no products moving, distillers that don't actually make the bottle size that's required, and everything in between. And let's go back and talk about if we can get some relief, especially with an extension another 4 weeks. Can we go back and make a case for delivery of these made on site, sealed, and sent out the door? So I communicated last night that we weren't going to talk about alcohol anymore, which we're not publicly, but we are going to try to see, can we make a business case to the governor that says, we can keep people in jobs and we can get the supply chain moving, just like we did in retail with grocery, and make that case together in a very thoughtful and data-driven way, right? So the PR, and noise and a lot of what we did was awesome, and it got their attention. But when you're leadership in a state like our size, and you're in a crisis of the kind of spread that we think we're about to see across North Texas and parts of the South, we just want to be not tone deaf, and we want to be very thoughtful about that. So that's just sort of the broad update when it comes to, gosh, alcohol, which seems to tie up so much of my time these days, which is hard to believe.
Thank you.
So, yeah.
So a couple of things for everyone to keep in mind. We are past 9 o'clock and we're trying to keep this as succinct as possible. You've seen that we do these frequently now. And we will continue to do so. We do have another webinar coming up on Wednesday afternoon. I'm very excited to announce that Senator Cornyn is going to join us on that one, along with some people from SBA, the Small Business Administration, to answer questions specifically related to SBA. So I'm very much looking forward to that. It'll be great to have the Senator with us. He's a big supporter, obviously, of small business and restaurants in the state. So that'll be lovely. Ethan and Talley, it was great to watch the sunset from behind you and your window. So thank you guys very much for joining us at night. I know this is a little unusual. Again, JacksonLewis is part of the TRA Law Center, and if you are a TRA member, you do have access to them when they can fit you in. We keep them very, very busy right now, and they also have additional clients right now too. Thank you everyone for chiming in. We received a lot of questions. The next time we do this, I really would recommend everyone send their questions in advance, because it's so difficult for us to get to the questions that come up during the chat. And it gives Emily and our guests another chance to prepare for the webinar as well. Just a reminder, Wednesday at 2 p.m. will be our next one, and that's the one with Cornyn. And I guess that's really it, unless Emily or Talley, you guys want to say anything?
No, I just want to say we will. Someone asked about the webinar link. We absolutely post all these webinars so you can go back. I'd encourage all of you to go back and listen to the JacksonLewis webinar around Families First, as well as the Texas Workforce Commission. They're both posted on TRA.org, I think COVID-19, right? I think it's our resource page. And we have everything now by topic. But I would just encourage you as you're getting into this April. And then, of course, we're kind of here 7 days a week. So if we can help anyone tomorrow or point you in the right direction to maybe someone who already has some answers, reach out to us, because we know personally that this is a lot of information to sort through.
Yeah, and I just last thought for me, I would too. I encouraged it during the last webinar, but take advantage of all the free content our law firm puts out. JacksonLewis.com. We've got 950 lawyers who are looking at all of these issues, generating new content. And on the front of our webpage right now, it says, I think, COVID-19 Task Force. If you click on that, you just scroll down, and we're putting out so much content each day on all the shelter-in-place orders, on all of the new legislation that's being passed, new guidance issued by DOL, EEOC, every day on these issues. It's all complimentary. Take advantage of it. We've got all of our webinars on these issues archived and available on demand on our website too. So www.jacksonlewis.com.
It's awesome.
Great.
And you can trust it, right? I mean, I think one of the things we're finding is people are posting lots of stuff, and different nonprofits are posting stuff, and it's not always correct. And so when it comes to this really serious stuff, you know, attorneys or associations that are vetting things federally is the right way to go. So if you find something and you're unsure, there's two conflicting opinions, reach out, and you know, that's what we're here for. So we'll help you find the right answer, but also the correct answer.
Great.
And if we're wrong, we'll admit it, because I'll tell you, we are real time. So if we make a mistake, we'll tell you, but we are sorting through it as fast as we can.
All right. Thanks, guys. Emily, have a good night.
Thank you all.
Ethan,
Thank
Talley,
you.
thank you. Good night, everyone.
Thank you.
Thanks, guys.
Bye-bye.
Bye. Thank you.